Self-Justice presents What Happens to the Matrimonial House in Separation Divorce. What is a matrimonial house? They are properties in which spouses live together as married spouses. Therefore, only married spouses have matrimonial houses. It is possible to have several matrimonial houses. For example, both your house and cottage would be considered matrimonial homes. The matrimonial house is a special asset, meaning that the Ontario Family Law Act gives each married spouse an equal right to live in the matrimonial home after separation, regardless of who owns the house. This legal right prevents one spouse from throwing the other spouse out. Either married spouse can apply under the Family Law Act for exclusive possession of the home. It does not matter who holds the title to the house. Courts can grant such an order as either a temporary or final order. However, courts, even on a temporary basis, will rarely make such an order because it is a very harsh measure, since it deprives a spouse of the enjoyment of his or her own home and forces them to find other accommodation. Usually only in extreme circumstances, such as violence, an intolerable living situation, and/or a spouse who cannot afford other accommodation, will the courts consider an order for exclusive possession. What are the factors the court considers in granting possession? The factors that the court will consider in granting possession is 1. Best interest for the child. 2. Financial situation of each spouse. 3. Availability of other accommodations. 4. Existing support orders. Also, judge will consider if there is any domestic violence. Common laws are limited to their ability to get exclusive possession under the Family Law Act. Common law spouses can try to get exclusive possession through other mechanisms. First, common law can have a trust claim for the home, resulting in an injunction, which allows the spouse to stay in their house until the issue has been resolved. Second, Section 34(1)(d) of the Family Law Act provides a mechanism for them to seek relief regarding the family home. They can apply for spousal support and, by extension, seek an order for the exclusive possession of the matrimonial home. Third, you can obtain a restraining order under Family Law Act or the Children's Law Reform Act. The possession of the home could be a consequence of a restraining order instead of being the purpose of the order. Thank you for listening. Check us out at selfjustice.ca for more free legal resources for self-represented parties.